I would like to say that the topic of our roundtable discussion is
Форма более или менее традиционна.
It is traditional for our forum, and we reserve some time always for questions and answers, and we always discuss issues of general law because we think that it is very important for the future law and application of law. In our ministry, we had a competition. I won this competition, therefore I'm the moderator of this roundtable discussion. And as a moderator, I decided also to reserve the role of one of the speakers. You will have to endure me not only as a moderator, but as another speaker who will take 10 or 15 minutes of your time and try to identify or outline maybe those areas of discussion that might be interesting for our distinguished colleagues with whom we share this room now. And probably they will also make some comments or add something, or maybe disagree with something I will say. Well, first of all, approaching the topic of our roundtable discussion, I would like to say that I think that from the very beginning, the doctrine of natural law came from a hierarchical structure of the world. Ancient philosophy, where the ideas of natural right law were born, they could do that. That's such a non-politically correct things. And they understood and recognized the priorities of the sacred over secular, and the priority of rights of the group over individual rights. Pompeius once said what you just heard in Latin, when certain ideas, certain values were more important than human individuality, and this was considered to be something that is taken for granted. Of course, the theory of natural law, no doubt, was peaked in Thomas Aquinas' days, where the vertical hierarchical integration of human society prevailed, and that was the most pronounced in the human society. I don't even mean the structure of the feudal system or society that we know from our school curriculum, and not authoritarian trends in those days. I mean the clear-cut hierarchy of values and ideas. And this overall environment, in my opinion, was especially fertile for the development of natural law ideas. Starting from Renaissance epoch, mankind started a multi-century-long process of transiting to horizontal hierarchy, which means extreme axiological or value-based pluralism. Naturally, the ideas of natural law started to be criticized on a large scale, on a mass scale, in two main areas. Number one, discreditation of natural law as an existing and applied in reality legal model. People said that it has nothing to do with reality and cannot be applied in the real world because it is abstract and cannot be used at all. And the concepts were kind of switched. Natural law in objective sense was replaced with natural rights in subjective sense. The moderator of the plenary session probably insulted a little bit Professor Finis, because he said that his teachers were Locke, Diderot, Grozzi, and other outstanding philosophers and lawyers, because maybe Professor Finis's ideas are diametrically opposed to those ideas. But this criticism exists and remains quite just and fair. Utilitarianism, as represented by Bentham School, Austin School, in the 20th century, became pragmatic and simplified understanding of the law. But at the same time, it was a natural consequence of a more profound and deep philosophical trend, which was started by Plotine. It was strengthened by Augustus, Thomas Aquinas, René Descartes, and in the 20th century it was expressed in Neo-Aquinas Theory. We reject something irrational and replace it with something rational. We think that it is especially typical for Western society. Of course, St. Augustus and Thomas didn't want all of it to lead to such an outcome, and their successors, as a result, were reduced to the notion that moral is a totally abstract, irrational concept that cannot have anything to do with law and law enforcement. I don't think that morals is a threat to the understanding of law, because it is not a component or alternative to law. Law, in relation to morals, or although both are certain social regulators, is a simplified and pragmatized imperative that is aimed at its ubiquitous nature. And of course, the viability of the concept bonus pater familiae in the Soviet law, we had similar models where laws are geared towards some average level of understanding of the law that is readily accessible to any person who is intellectually valid. We think that the relationship between morals and law are of gnoseological nation. The morals was one of the sources of law, which was formed with taking into account the moral imperative. Axiological. This link is also axiological or value-oriented, because it is moral to comply with law, and here we have such a stimulus as the moral duty, some kind of ethical imperative, which may be either at the top of the Maslow pyramid or very close to it. So, in studying law together with morals, I think that we don't see anything bad there, because in the Western understanding, rationality covers many aspects of what many other people call morality or ethnic values. It is well known as a concept of a reasonable man, good reasoning in the Anglo-Saxon common law. You can see it in the case law, and probably it is also manifested in the theories of practical rationality that esteemed Professor Finnis is proponent of. However, if we completely reject moral roots, it will not enrich, but rather diminish the role of law. And on the other hand, the understanding of the role of morals cannot be an impediment. And this is bringing me to the end of what I wanted to say in this part. We can say that natural law is an absolutely pragmatic and rational phenomenon. Probably you have already guessed that I am proposing some kind of a synergetic approach to the formation of the law and application of the law. So this is a road that includes all levels of cognition, thinking, empirical level, rational and irrational or ethical. So the result of the interaction of these components is the formation of principles of law. The understanding of legal principles may be different. The overall humanitarian approaches that can be seen in the Anglo-Saxon model of legal policy, ideological concepts like Marxist-Leninists, ideological postulates, as well as weaker political postulates came into the fore depending on the political context. And also we have specific but universal norms that are enshrined in any kind of legislation, and targeted decisions or solutions can be found in the rulings by some courts. This pluralistic approach is understandable, but it is not always useful to understand what legal principles are and their role, what their role is. I think it is absolutely detrimental if we understand principles of law in two possible aspects: as ideological concepts that can be changed depending on the political context. This approach was flourishing in the Soviet doctrine as well as in Western doctrines, and some scholars followed it. The understanding of principles as just another set of norms, probably with a special status, but must be directly fixed in the law and regulate specific cases. In reality, legal principles, I would like to stress this idea that I'm trying to share with you, something that formed in accordance with the objective laws of human physiology and psychology, societal physiology, overall algorithms of interaction between people, which is conducive to fully tapping of human potential, freedom of individual, prevention of conflicts, and ensuring the balance of interest in society. The number of academic fields that can be applied in formulating these principles, their list can be endless. But the main idea is that the existence of man as such and in society is objective and logical, and then it becomes quite clear what kind of role legal principles play. I think legal principles cannot directly govern relations between people, although they have some regulatory role to play, and within one regulation you can resolve a specific case. But of course the principles can create a framework for this regulation. Fairness, reason as the basic principles may and should be specified in specific laws and in court rulings. Legal principles cannot contradict one another and cannot lose their stability. I think to follow legal principles is, well, up to everyone. You have to choose between lawful and unlawful behavioral model, and depending on your choice, the relations begin based by law or otherwise. The principle may be enshrined in positive law, it may be recognized or not recognized, but it doesn't stop to be a principle because of that. What in the USSR we had a limited understanding of contractual law and principle of integrity of one's property. It wasn't the problem of the principle, it was the problem of the USSR and its citizens. But there may be an accumulated era when these principles are developed. First at the stage of understanding and formulating the principle, then at the lawmaking stage, and the law enforcement stage, and then at the basic level, the choice of a human being, of a lawful or an unlawful model that is in line or not in line with the basic legal principles. When these errors accumulate, certain inertia-based processes start. We cannot judge them objectively and assess them objectively. Unfortunately, it's not possible. We can only guess by using some indirect signals. And when we observe certain defaults that sooner or later ensues any deviation from legal principles. We may understand, which is unfortunate, that some time ago we deviated from legal principles and now we reap what we have sown then. So, as a result, if we apply legal principles, it creates legal energy in the society, and it may at least help the society to survive or to be able to fully open up its potential. Legal principles are a kind of a mesh structure which may be filled with honey or it may be kept empty. And you can keep honey in a good beehive or throw it away. So it is just a joint in which the bone moves in the most convenient way. So understanding that legal principles is natural law per se in an objective sense. This is understanding it is not in line with the proposal by Ronald Dworkin, who tried probably to work on this category in the most thorough way. It is much closer to the understanding by Professor Finis, whom I will give the floor in a moment. But finally, coming back to my presentation, I would like to say modern world has entered a stage of an active transition to this horizontal integration or a network integration, which was pluralism of plurality of values that was mentioned, is characterized by the modern day concept of big data, which is used by the most advanced managers and businessmen. Huge databases, huge number of approaches, huge logical models, and each of them have a right for existence and recognized as such, in which traditional logic, traditional values are getting dissolved. This overarching approach allows us, on the one hand, to have more chances to generate something useful for society, but let's agree it also creates serious risks for global manipulation of consciousness.
And these are the new realities which we need to think about how to realize law in. And for corporations, for projects, for the law, for people and community, when people feel themselves more insiders rather than outsiders, and we can also come up with criminal in commerce ideas that the professionals are more in demand in the world, and the lawyers might be an obstacle on their way from point A to point B. I think that in this context, the principles of law would be transforming, and they would be going to the periphery of our life and logic, and perhaps this is the healthy optimism of my speech, but they won't lose their significance. Perhaps there is a magic box which contains the destiny of humankind and the ultimate goal of humankind that needs to be achieved. And the principles of law will remain the key to this magic box which sometime in future somebody would pull from the top shelf and would want to open that magic box. Thank you for your patience, and I have this actually proposal for you to ask questions in the end of our session so that all speakers would have time to speak first and then have a Q&A. I already announced that I would give the floor to Professor Finnis, Professor of Law and Philosophy of Law at Oxford. Indeed, if at this fifth forum we only had this speech by Professor Finnis, it would still go into history of all the fora, because he is a person who had discussions with Hart, Dworkin, Kelsen, with utilitarians, Professor Higgins, who is an equal partner and participant in the deliberations. He had the time to speak at St. Petersburg University. He also spoke at the plenary session, and now I would like to give the floor to Professor Finnis, please.
In the program, you can see for this session a prospectus, which, if you analyze it, comprises 7 questions. And when I received this prospectus last week, I thought, well, perhaps I shall answer all the questions. Now, this is a very foolish, unreasonable enterprise, because to answer very many of the 7 questions would take 500 pages. But I have written a lot of pages over the years, so on abstract questions of this kind. So I will do that. My colleagues, I think, have all been much more sensible and have taken specific aspects of our problem, but I'm attempting to deal with all. I came, as the Minister said, I've had the good fortune to interact with great teachers and colleagues of mine, H.L.A. Hart, Ronald Dworkin, Joseph Raz, and a good many others. I, in fact, came from a rather egalitarian society as a student, Australia, to Oxford and did a thesis with Hart. And at the end of that, after he had more or less secured me a position, the one I held for the next 45 years in Oxford, he said to me, would you write a book for my series, in which his great book, The Concept of Law, had appeared, a book called Natural Law and Natural Rights. He specified the title, and so I said, yes, I will. I'll do it in 3 years. He said, don't hurry, so I took 10. And that's the book that it attempts to answer all these 7 questions. I taught with him, I taught with Dworkin, and then later in the 1990s, still in the same position, but extending my teaching to an American university, I had the opportunity to teach courses on Thomas Aquinas, whom the Minister mentioned more than once. And I wrote a book on Aquinas' moral, political, and legal thought. And so what I have to say to you this afternoon is partly a result of Hart's invitation to think about natural law and natural rights, and partly a result of my teaching with Hart and Dworkin, and partly a result of reading and thinking deeply about the theory of Thomas Aquinas, who had the ambition there in the 13th century in Italy and France to absorb the whole conversation of philosophical thought about morality and law from the earliest times that he could be in touch with, before Plato, Aristotle, Augustine, and all the fathers and all those philosophers of his time. So I will consider each of the 7 questions, but I will follow a slightly different order so as to group together the questions that seem to me to cluster together. And I think first there is a group of 5 questions of the 7, 1, 2, 5, 4, and 6. So the first question on the program is the foundations of law. Where does law come from? And that first question has two different senses, very different and important to keep distinct. The question might be understood, or reasonably understood, as asking about facts, about the factual foundations and origins of a group's laws, in the customs of the decisions made by or for that group. Or similarly, about the factual foundations and psychological origins that are characteristic of positive law, whether customary law or statutory law. In general, not just in this group or that, but across all human societies that can be said to have had law. The very notable St. Petersburg legal theorist Leon Petrozhitsky, whose work I first heard of in Australia before I started reading law, and I read a book about legal philosophy, and there his name came out to me for some reason. I was in Australia as far away as you can get from St. Petersburg, but for some reason his name and what the book told me of his theories remained with me. So it's a great privilege and delight for me to be here at last in St. Petersburg, and for me yesterday to have the opportunity to address his university, where he was the professor of the philosophy of law for 20 years, up to 1917. He gave a powerful account of the empirical, factual bases of law. Law in many domains, not simply the positive law of states. And on his account, this empirical basis of law, the fundamental empirical basis of law, is the emotional psychology of, to put it very briefly, experiences of duty, emotions that are then projected as rules or other norms and are reinforceable by positive laws motivating and educating roles. Positive law, in Petrozhitsky's account, has two fundamental roles of motivating and educating. He could have investigated the evolutionary or other biological or historical bases of those emotions, but I think he did not. But none of this relates to the other sense of that question, where does law come from? And that's the sense that I will myself focus upon this afternoon. There's this other line of inquiry altogether, in which one is looking not for facts or psychological motivations as facts that one could report about other people or about oneself, but instead one is looking for reasons for action, reasons to choose some kinds of possible action or outcome, and to reject or avoid some other kinds of conduct or action. Now one is considering oneself no longer as simply an observer of causalities and empirical possibilities, but also as someone who needs to act, and needs to act appropriately, justifiably, fruitfully, and reasonably. And one is considering possible states of affairs that one might achieve or attain or avoid. One's considering those states of affairs as good, desirable, intelligent to bring about, and so forth. And one is considering them not merely as good, not merely as a means to some other good, but in the case of some states of affairs, as inherently good, worthwhile in themselves, for their own sake. Now, if one then reflectively or philosophically considers the whole range of one's own or anyone's opportunities, the whole range of the deficiencies in or threats to one's own or anyone's flourishing, it's evident that that range has a structure in which what is foundational for all practical reasoning, all thinking about what to choose and do, what is foundational is a set of opportunities that are each a fundamental aspect or element of human well-being, a set of goods from which one benefits not simply as means to other benefits, but also for themselves, and that are intrinsically beneficial to anyone and everyone else. These goods give shape to one's practical reasoning, one's deliberation towards choice, by implicitly or explicitly directing that thinking in the form of first principles, propositions of this form. Life and health is a good to be pursued, and what threatens it is to be avoided. Knowledge is a good to be pursued, and ignorance, muddle, error, etc. are to be avoided. Friendship in one form or another, and there are many, is a good to be pursued, and hatred, malice, and other forms of disharmony are to be avoided. Marriage, in which one can hand on the gift of life in friendship with another potential parent, to whom one is committed in friendship with all the exclusivity and permanence that fits the spouses, not only to engender, but also to nurture and protect, educate the children who will be forever only theirs. That's a good, and incapacity for marriage is a profound loss, and committed celibacy is a profound sacrifice. Mastery of materials in crafts, arts, games of many kinds, concerts like the one we had the privilege of hearing last night, mastery of classical piano and jazz piano and all the other arts that we saw displayed before us. This mastery of matter is an intrinsic good beyond whatever other valuable product that mastery may achieve. And finally, mastery of one's own choices by intelligence and reasonableness, extending its rule constitutionally over one's emotions or within one's emotions in integrity of life and authenticity of choice and action. That's a final basic good. And these, I think, are the foundational, intelligent and true intrinsic reasons for action. First, principles of practical reason. Whether the intelligent grasp of them is then developed morally or immorally, because these first principles are not yet themselves moral principles. They are directive, they're normative, and they're the rational foundations of morality, but moral criteria of choice come into view, and the normativity of the first principles becomes moral normativity only when one considers first that these basic goods to which these principles each direct us are indeed many. There are many of them. I listed 6. And they cannot all be pursued and achieved at once, even in one's own individual life. And second, they are each just as good in the lives of other people as in one's own, my own. And third, that for both these reasons, there is a problem of prioritizing and adopting reasonable preferences and criteria for choosing or rejecting options, proposals for action, even though the rejected, non-preferable kinds of action would be intelligent and purposeful. What we call morality, not as a report about other people's emotions or opinions, or one's own as a fact about oneself, but rather as a set of principled criteria of practical reasonableness, for example, of justice or of reasonable courage. This morality is the set of rationally justified answers to those questions about priorities and about what one or anyone should avoid or abstain from. If the first pre-moral principles of practical reason are called in the tradition, as they are, first principles of natural law, then their general moral implications are called principles of natural moral law, or natural right. The set of moral duties, positive and negative, that we all have is structured by such master principles as love of neighbor as oneself, and the first implication of that principle, the golden rule of fairness, summoning one to do for others what one would want others to do for oneself, not to do to others what one would not be willing for them to do to oneself in similar circumstances. The general moral principles or norms exclude all choices motivated by desire to destroy or damage a basic good in anyone's life for the sake of the destruction, which is acting out of hate, or even as a means to achieving some genuine good, which is doing evil for the sake of good, in the language of Paul, or treating humanity in oneself or others as a mere means, in Kant's formulation, one of his formulations of the categorical imperative. It does not exclude either reasonable measures of forcible self-defense, intended not strictly to be damaging or lethal to the attacker, but to stop their attack, though one foresees and accepts, but does not intend their personal destruction. Nor does it exclude legitimate punishments intended to restore the order of justice in a community by depriving the offender of the liberty of which he took too much in choosing to commit his crime. So now I'm in a position to respond, all too briefly, to the next three questions. The second of them was, from where do we derive our notions of right and wrong? Certainly it is a fact that we first get our notions of right and wrong from the admonitions of our parents and teachers. But these admonitions are testable, and as soon as we become interested in good reasons for actions, what we have learned from others is soon tested against our own understanding of the truths that there really are good ways of being a person and bad ways. That good here signifies not only attentive to real possibilities or opportunities, but also just, loving, and in other respects integrally reasonable, and thus right in one's choices and dispositions, while the term bad similarly broadens out and focuses in to include unjust, unloving, selfish, malicious, other ways of doing bad, wrong, evil. So our critically developed judgments can test, reject, or reform the standards of right and wrong that were offered to us as moral in our social context, difficult though that is to achieve a critical independence of mind. And the legal principles the minister spoke of and illuminatingly of in a way that I can't now immediately pursue, themselves are articulations, many of them, of moral principles of fundamental kind. Now, implicitly, as you may have noticed, I have already answered in principle question 5, fifth of the 7. What are the roots and substance of our most cherished values? The word values ambiguously refers both to basic intelligible goods, such as those that I listed 6 of, and then it refers to any and every good that can be a means to basic goods. And also it refers to moral goods, of responding reasonably to the desirability of those basic goods in one's own and perhaps many other people's life. Cherished values are usually some mixture of these 2 or 3 kinds of value, and they are more to be cherished if critical reflection shows that they are appropriately cherished. Since neither love of neighbour nor the Golden Rule commands a flat egalitarianism, but rather each directs us to reasonable prioritization in love and responsibility, rightly cherished values include gratitude to one's parents for their fidelity in nurturing one, and to one's society for preserving the cultural capital which enables one to join the life of the mind and other interactions, other skills, with all the treasures of insight and judgment that are embodied and transmitted in a language, a literature, the arts, architecture, in reasonable customs, in protection against bandits and invaders and ill health and destitution, and in a set of legal principles and legal institutions, and so forth. And the cherishable values include also a sense of vocation. What? The vocation to add to these treasures for the sake of oneself, one's fellows, and those who will come after. So we're in a position now to tackle question 4. Are there fundamental precepts respected in every faith and every society? Well, the fundamental pre-moral principles are acknowledged in any society that is not heading to prompt dissolution and extinction. And the fundamental moral principles that shape the pre-moral into their moral implications are acknowledged with various degrees of imprecision, and their implications are usually grasped fairly accurately when one is the victim of others' injustice, but less accurately when one is tempted to or hardened in injustice of one's own, an insight which St. Augustine memorably expressed. So the de facto respect is historically and perhaps currently patchy, variable, mixed. But few people or peoples, religions or societies are completely closed to intelligent criticism or completely beyond a moral appeal to conversion to the more adequately reasonable and self-consistent. The way down or up from the basic principles of practical reason and reasonableness to relatively specific moral norms is a way long enough for any obscurity or defect in the understanding of principles or in the inferences will yield diversity and disagreement at the level of specific moral norms and judgments. Cultural bias overlaying reason can be expected to distort traditional or merely traditional mores, judgments, and perhaps severely distort them. But we are not trapped irremediably in such distortion and error. Well, question 6 continues or extends question 4 and asks, are there differences in the precepts and values of different societies, and are they justified, or should anyone judge? The answer is, again, that indeed there are de facto wide differences in specific precepts and practices, but also much convergence in judgment, especially at the level of principle, before differing guesses about the future or the past are factored into the social answers. Certainly, we have no reason to despair of critically justified judgments, no reason to say that everyone's judgment is as sound as anyone else's. Everyone must judge, but everyone is at risk of moral error, which would be impossible if there were no objective criteria, true judgment in moral matters. If no truth, then no error. Question 3 asks, is religious faith necessary as a foundation of just law? The reference to just law suggests that the attention of the writer of the program, has now switched or turned back to positive state law, which can be assessed as just or unjust by the standards of the natural moral law, especially justice, often spoken of today as respect for human or other rights. Every people needs some of its members to assume the responsibilities of making decisions on behalf of all, especially, but not exclusively, by legislation and executive or judicial application of laws. That need for authority, and for legally regulated authority, can be spelled out in great detail. It is a requirement of justice and of love to escape from and minimize the standing danger of anarchy and of tyranny. Now, do we need religious faith to understand this need for law and need for law to be just? or to understand what the principles of justice are? Well, faith may suggest belief in, that word faith may suggest belief in some more or less specific body of allegedly revealed divine instructions. But before it is reasonable to adhere to such a belief in an adult way, it's necessary and possible and reasonable to make a rational judgment that the world has some transcendent source of its existence, its maintenance, and its astounding intelligibility, which is unfolded and deepened every day in the natural sciences. There must be a transcendent source of nature, and therefore beyond nature, prior to nature, one that conceives and creates the natural universe, including our own intelligence and our own freedom of choice, and creates it by an unconstrained, originating, free choice to create from nothing. The greatest philosophers, Plato and Aristotle, themselves moved impressively and decisively towards such a rational judgment by strictly philosophical means. But the Hebrew prophets, thinking and speaking non-philosophically, reached philosophically superior and even more defensible judgments about creation, the Creator, freedom of the will, and human equality, and therefore justice. So, it turns out, there is one critically justifiable faith which believes these prophets and the yet greater prophets whom they foretold, whose clearer and richer disclosure of divine purpose they foreshadowed. What is notable about that faith is that it teaches that the moral law is both revealed, as in the Decalogue promulgated by Moses and repromulgated by Jesus of Nazareth, and natural. Naturally, that is, rationally accessible in principle to anyone, even without the benefit of the Mosaic or Christian revelation. That's the teaching of Paul in his letter to the Romans, chapter 2, verses 14 to 15, as was recognized and affirmed by such great Eastern fathers as Justin Martyr, Athenagoras, Irenaeus, Clement of Alexandria, Cyril of Alexandria, John Chrysostom, Maximus the Confessor, and John of Damascus. So the answer is, I believe, that religious faith is not necessary, but is most helpful in clarifying and making more certain what can be known without it about justice. Atheists, such as Leon Petrozhitsky seems to have been, have found difficulty in affirming the true intelligibility and rationality of sound moral judgments, reducing them to expressions and projections of a form of emotion. Thus, even when, like him, Petrozhitsky, they affirm an ideal of love, and like him take many details of their account of love from the New Testament, their teaching is to some extent undermined by its inability to affirm that this ideal and what it demands of us is a truth of reason, rejection of it an error. So finally, 7. How should our perception of law and morality at the level of the individual and under domestic law translate into public international law and the conduct of states? As I indicated briefly at the end of my address to the plenary session yesterday afternoon, public international law is not, in my view, a central case of law, for it is not made by anyone who has a continuing responsibility to exercise authority in and over a complete community. Insofar as it is posited, non-central form of positive law, international law is really a vast network of more or less promissory obligations, voluntarily assumed by states. Beyond that, it is a domain of universal moral principles, the rational foundations and something of the content of which I've been sketching in my response to the other 6 questions. States and statesmen are in no way immune from the rational demands of love of neighbour and of the Golden Rule. The Golden Rule is at the heart of the obligation of promises, and it incorporates the truth that friendship is a basic human good that human beings are equal in all sharing in a single nature that has the character that no other animal we know of has, the character of being spiritual, in this sense, that each member of the race at all times has at least the radical root capacity, even if that capacity is undeveloped, obscured by disability, the capacity to understand propositions such as laws, reason from one proposition to another, and to understand the normativity of sound inferences, and the further practical normativity of practical reason's first principles, and their moral implications, and the capacity to ask critical questions, which I expect you'll want to do. Thank you.
Большое спасибо, уважаемый профессор.
Thank you very much, dear Professor. It was a fundamental presentation with which Professor Finnis, well, with his usual thoroughness and rationality, has answered to all the 7 questions that were formulated by organizers, by the speakers as a guidelines. We never expected such thorough approach and never expected speakers to answer all the 7 questions, but as a preamble to our discussion, I think this particular high-level approach demonstrated by our professor is very useful and creates a platform from which we can start on which we can start our discussion. And now we have a good opportunity to turn this discussion into a more practical plane. The next speaker is not only a practicing lawyer, he has a lot of experience like that as well. He does much more important things that are in between the search for universal legal principles and their implementation in practical norms. Mr. Mazzoni, I would like to give the floor to you. UNIDROIT Institute of International Private Law Harmonization. Please, you have the floor, sir.
Dear guests and friends, please prepare yourself to come down from sky down to earth, because I'm not going to try somehow be on the same level as Professor Finnis has been in this wonderful presentation. I will be more practical. I will be simpler, but still I will have to evoke certain basic problems that law has faced in its evolution. And so, in a sense, although ultimately I will refer to the practical possibility of using certain things, the principles that UNIDROIT elaborates, although I will make reference to that, I will start from certain statements concerning where we come from in terms of positivism first, and then a reaction against positivism. Now, I will first of all refer to the atmosphere that has prevailed in particularly continental Europe, but in the 19th century. There has been a triumph of legal nationalism. Legal nationalism has induced every country to consider that the law had to be national as the national anthem or as the flag, and that created in turn the idea that the real law that should be applied in each country was the national law as uttered, as explained or produced either by parliaments or by judges. And the extreme application of this idea is positivism. There is no other law than the law of the national state. So, in terms of each individual state, the idea was that the state created a monopoly of the law. The applicable law was only the law created by the state itself through its processes of creating laws, or if the law came from other sources, it was national law to the extent that it was validated by the state. And in international relationships, there was no room for creation of laws by individuals or by entities. International law was simply the law of relationship among states. And this has created a postulate, a sort of postulate. There is no law other than state law. And state law meant positive law. And now it is against this postulate that there were reactions in the past, and there have been reactions later on, and there should be reactions even today. Notwithstanding the fact that a lot of my colleagues, both in the academy and in practice, consider that those who want to take a distance from this attitude, this postulate, are dreamers, because in reality the law is positive law. And I think that they are profoundly wrong, as I will try to indicate. First of all, the fact that law is not just positive law may be shown by referring to an intrinsic necessity for law of searching for a balance between two opposed needs that law feels. On the one hand, law needs certainty and predictability, and that drives law towards formality and rigidity. And on the other hand, law needs to adapt to social changes, needs to evolve, and therefore law needs to have a certain intrinsic amount of flexibility. This is not just a philosophical consideration, it is something that history proves. Need only to refer to the difference between jus civile and jus gentium in Roman law, and in the history of English law, the distinction between common law and equity. Now, equity, the best of my recollections, my studies as a comparative lawyer, equity started very soon to become a parallel system of law, and not just a set of moral rules. However, from the very beginning, the political justification for having equity was that one could not admit that the rigidity and the formality of the law would prevail in cases where the outcome of application of the law would be moral injustice, a result that could not be accepted from the standpoint of morality. And so we see from the very beginning an idea that you can't simply assume that law is just positive law. Law needs within itself interactions with society, interactions with morals, and has within itself the need to evolve through sources that are outside of the law-producing mechanisms. For the purpose of what I will finally want to say here, the importance of the principles that are elaborated by Derive, I think that I need to refer to an old distinction that existed in Roman law, and that has been later on evoked again in the context of more modern experiences. I refer to the distinction between jus and lex. Lex is, in Latin, reference to a set of rules which are laid down in a specific statute. And so there is a very precise objective purpose for the lex. Jus is a much broader concept which includes not only the statutes, but also the judge-made law and other injections coming from the social development of society, and it's the system, the legal system as such, either one branch of the legal system or the legal system as such. Now, this distinction continues to be used even in our present way of thinking of law. You have in French, the distinction between les droits et la loi. In Germany, das Recht, das Gesetz. In English law, you have the distinction between statutory law and general law or judge-made law. But all of these distinctions, although coming as an application of the old Roman distinction, immersed in an atmosphere where law is synonymous of state law, have been used essentially for drawing distinction within one legal system. So it's a sort of a comparison between the parliamentary or governmental administrative sources of producing law in a formal sense and other sources of producing law, but all within the conceptual boundaries of law as being state law. But I want you to draw your attention to a different phenomenon in history which took place in the Middle Ages, where this distinction between jus and lex has a different significance, and has a significance of establishing a sort of hierarchy between the local, contingent, historical, variable laws, local, and use in that sense, the superior, universal set of principles based on reason, which can be used when you cannot, as a practical lawyer, solve problems of a specific nature. And I am referring, and I must here open a bracket, I'm a scholar of commercial law, and I love history of law, and I'm thinking of the formation of commercial law as the preferred area of studying the legal phenomena. Now, in the Middle Ages, at the time when the civilizations of the cities in Italy and in other countries of the continent, but even in England, there were rules concerning the trade developed, established directly at the level of the single municipalities. And the idea was that when a merchant coming from one city would have a trade with a merchant in another city, and there was a dispute, the idea was that one should look for the good substantive rule to apply. Conflict of law ideas of von Savigny is something that happened in the 19th century, and it's part of the phenomenon of nationalization of laws. But at that time, the idea was, what is the best appropriate rule to be applied in a situation where the two parties had two different national laws brought on their shoulders, in a sense. In certain cases, lawyers had to apply the territorial law because there were public policy reasons. But this was very limited at the time because the state at that time simply wanted to have taxes but did not want to interfere with commercial relationships. So essentially, it was a question of choosing between two respective personal laws. If the statutes of the two cities involved, cities from which the two merchants came, were convergent, it was the easy question because it would, the judges, the commercial judges would apply the common rule, which in turn became even more tested in courts, even stronger. But there were cases where there were no convergent rules, or the convergent rules were not felt to be adequate to the case. And then the idea was that one should step up go above the level of contingent local laws and would have to find the solution in what was considered to be the common cultural heritage. So law based on reason, ratio scripta, the written reason, which at that time was considered to be Roman law. But I'm not so interested now in referring to the fact that this is another example of how marvelous monument Roman law has been. What I'm trying to say now, to come to the point that I wish to make here, is that for centuries there have been ways of making law progressing and finding solutions and creating a facilitation of trades through the fact that it was possible to take distance from local contingent laws and look for the answer in law based on reason, law based on shared common cultural values. I think that this is of great importance even in today's contemporary world, and we have to learn a lesson from what has happened and from this possibility of looking in a non-state law, in a non-positive law, whereby the lawyers can find an answer to questions that at the level of local laws are either creating a conflict, or if the conflict is resolved through a rule of conflict, the prevalence of one law may not be necessarily satisfactory, it may take by surprise the other party, and a number of other problems that I will not evoke here. But what I'm saying is that the past experience shows that a system of non-state rules of law going above the level of local laws may be the solution for certain difficult cases. Now, I don't want to be entirely enthusiastic about this, because clearly you have a system of non-state rules of law that may facilitate trade. This may permit to escape democratic control of states. So merchants, international merchants, love the idea of having their own laws without the filter and of the judgment made by parliaments. But there are cases in which these transnational rules, as we can call them today, non-state rules, may fulfill a useful function. And it is always important to preserve for the states, for the positive law, the possibility to enforce the national values that a country wants to protect against anybody else or against any other rule. So the idea of having transnational rules based on reason is not an idea that wants to do away with the necessity of complying with imperative rules of individual states. But it is a great progress where imperative norms are not at stake, to have the possibility of using, rather than state laws, non-state rules of law, such as the principles that are elaborated by the institution that I have the honor to represent. And I now come to referring explicitly to the principles, the derived principles of international commercial contracts, which were launched for the first time in 1994. It was something that was thought necessary to complete the Vienna Convention on International Sales of Goods, which for a number of reasons did not deal with certain aspects of the basic contract which is the contract of sale, it was too difficult politically to arrive at certain conclusions. It was thought that with the broader freedom that scholars have, they could create an instrument going from sale to general theory of contract, and including in that product a number of rules that in the Vienna Convention could not have been approved because of lack of a political majority for it. Now, the Unidroit principles are, in a sense, the modern lex mercatoria, something similar to what happened in the Middle Ages when a number of rules were created by the conversion of the local rules that were identical or similar, and the addition of these rules in certain cases created by these rules founded on reason. Now, in a sense, the modern lex mercatoria is represented by the principles. They were launched in 1994, second edition in 2004, third edition in 2010. I would want the whole world to know them. It is not the case, unfortunately, but there are countries in which the principles are more known than in others, and one of these countries is Russia. And one of the major contributors to the drafting of the principles is Professor Komarov, a fantastic, fine lawyer that has helped us, who has helped us a lot in not only drafting but also promoting the principles. Now, what is the big difference between the principles and the old lex mercatoria? The principles today are based on contractual freedom. They are used to the extent that parties expressly refer to them, choose them as an alternative choice of a state law. This opens a very theoretical, scholarly debate on whether it's possible for private parties to choose as a governing law of a contract a set of rules which are not the rules of a state law. The modern trend is for the affirmative answer, but there are lots of countries who would not accept that. But whether they are used by the parties as rules of law or as terms of contract, simply rules that the parties, based on the principle of party autonomy, decide to adopt to regulate their affairs, the first fundamental notion of the principles is that they are used when the parties want them to be used. But here, in this context, I wish to make an allusion, a very strong allusion, to the possibility that principles may be addressed not only to private parties for them to pick them up and to regulate their contract, but the principles may also be used and are impliedly addressed, not impliedly. In the preamble, it's simply stated, the preamble of the principles, that they may be used to interpret and supplement national laws or even international instruments. So the addressees of the principles are not only the parties who may pick them up, but are also judges and arbitrators. And increasingly, judges and arbitrators use the principles. A good friend of mine, Professor Ramberg, a Swedish, told me that he had once a conversation with an English judge, and he asked them whether one could apply the principles, and the answer, the ironical answer of the English judge was, yes, of course, provided you don't say it. There is a truth behind this. The fact is that even if it is not possible to bluntly say that an international case will be resolved by applying the principles, in reality, this may very well happen. The reason being that for a very large part, the principles are a sort of restatement of the common core rules that the theory of contract and the general parts of contract in many legal systems follow. So for a very large part, there's full compatibility because it is the extraction of the rule of reason as prevailing in major legal systems. And then there are certain rules of the principles that are not exactly the reflection of the common core, but in a sense, they are the solution for those questions that in comparative law have never been solved. There is a choice of the better rule. It's going back to the idea that when you have conflicts of differences, irreconcilable problems with the local rules, you may go and look to the superior wisdom of a set of principles based on shared common values. And to that extent, the potentiality of use of the principles in the way that I just described, in the open or even implied way in which they can be used by judges and arbitrators, may make the principle look like the old ratio scripta of the Middle Ages. And my personal persuasion is that positive law, nobody wants to abolish positive law. Positive law should not have the illusion or the temptation to consider itself to be prisoner in a sort of ivory tower. Positive law is constantly interacting with society, with other pressure. You may call them natural law needs or implications. You can call them contacts with the international developments in comparative law, particularly international trade. There are many examples of the necessary interaction, and I do not think that if the principles as a non-state rules of law phenomenon are being used by national judges or arbitrators to resolve cases, I don't think at all this is a bad thing. On the contrary, I think that it's a desirable result. I think it's a desirable development, and I'm here to emphasize this point. Thank you for your attention.
Thank you very much, Mr. Mazzoni, for your very informative presentation. I think that many people in this room and outside this room now are happy to know that unification of private law is carried out with the understanding of legal principles and the understanding that such unification must be of a conceptual nature. Today, many people will have a good night's sleep for the first time in many years. I would like to tell our speakers and the auditorium that we have completed that part of the presentation of the discussion when we could forget about time. We have 3 speakers left. I would like to ask them to speak 10 minutes each so that we could leave some time for Q&A. Now I would like to give the floor to one other representative of Oxford University. It in itself establishes a high level of this presentation, but it's difficult to imagine that such a fragile and beautiful woman is not only an expert in international relations, but also in armed conflicts of all things. And I would like to ask Annie Nudil about her experience and scholarly understanding of armed conflicts. Are those armed conflicts, any armed conflict to this or that extent? an example of such a default because of the accumulation of non-law-based energy in separate societies and relations between them. You have the floor, please.
As the Minister already suggested, I'll be talking about the moral and religious foundations of one of the oldest branches of international law, the laws regulating war. And this is a very appropriate forum for talking about it because roughly 250 years, it was here in St. Petersburg that the first formal treaty limiting the use of certain weapons in war was signed at the invitation of the Russian government of the time, the St. Petersburg Declaration. When we talk about the moral foundations of international law, why talk about the laws of war? Well, I believe that the task for us to get it right, the relationship between morality and international law, is specifically acute when it comes to the laws of war. Almost all laws have moral implications. Even the law of air traffic or trade ultimately has moral implications. But we don't think that you need a moral justification to merely engage in trade or air traffic. To the contrary, war, as the adage goes, is about killing people and breaking things. And even for the very endeavor of engaging in war, you need a moral justification because it is consistent of acts that we think are, without moral justification, unjust or immoral. So we would probably consider an international law that was divorced from morality, an international law trying to regulate warfare, inadequate. And indeed, international laws of war have a very ancient moral and religious pedigree. The contemporary treaties on international law, foremost the first additional protocol to the Geneva Conventions, has a very discernible echo of the thoughts of the 4th century, someone says the first Christian philosopher, Augustine of Hippo. I'll point that out during my talk, what exactly that is. But it is quite remarkable that we can trace contemporary international law to this very early Christian just war theory. So what I wanted to stress is that the laws of war are not only inevitably morally laden, more so than any other aspect of international law, possibly with the exception of human rights law, they're also the law with the most explicitly moral impetus or goal. What I would like to do over the next 10 minutes is highlight 2 ways in which the contemporary law of war nonetheless challenges our contemporary moral intuitions. This should be very surprising to us, given what I just said, that actually the law is very firmly rooted in ancient morality and ancient theology in some ways. So I'll point out 2 ways in which nonetheless, the law challenges our moral intuitions, and I'll explore some of the reasons, some of the moral reasons for why that is the case, to ultimately hope in a necessarily incomplete way to come to somewhat of a conclusion of what that means regarding the appropriate relationship between morality and specifically international law. The most fundamental divergence between contemporary international law and our moral intuitions is the asymmetry between defender and aggressor in self-defense. Imagine a scenario in which, in a dark alleyway, someone comes at you with a baseball bat and starts attacking you. We would, almost all of us, think that you have a moral right to defend yourself with violence. But that moral right, once you start defending yourself with violence, doesn't give your attacker a right to self-defense in return. So very crudely put, your cause in a fight, or the way a fight came about, matters for what is permissible violence. So this asymmetry between aggressor and defender is reflected in most domestic laws on self-defense. So we would then expect international law to also differentiate between the state that broke the most fundamental rule of international relations and started a war, and the state that merely responded to the attack. Yet international law doesn't distinguish, not at the level of the regulation of conduct. It gives both sides the exact same permissions and restrictions. An uncontroversial example, when Saddam Hussein invaded Kuwait in 1991, the law gave the same permissions, the same restrictions to both sides. Now, interestingly enough, just war theory, from the all-famous Augustine of Hippo to one of the most influential contemporary philosophers of just war, Michael Walzer, sides with international law, not with the moral principle of asymmetry in defense of harm that I just cited. Walzer states, I quote, "It is perfectly possible for an unjust war to be fought justly or for a just war to be fought unjustly." And he stipulated the moral equality of combatants on both sides. So no matter whether you're on the side of the defender or the aggressor, Walser would uphold that you have the same permissions and restrictions. Let me talk a bit about what those restrictions are. You're probably all familiar with the most fundamental one of them, which is the principle of distinction, which prohibits attacking of civilians, intentional attacking of civilians. The corollary to this immunity of civilians from deliberate attack, which we often overlook, is the permission that law grants to kill combatants. The law does not pose any limit for how many combatants you may kill or under what circumstances, with the exception of surrender or prisoners of war. In general, international law acknowledges that killing combatants is a military advantage. It is a legally privileged course of action. Now, that challenges one of the most fundamental moral principles anchored in natural law. One of the reasons we give for why we think there is such a thing as universal moral principles is that we share a common humanity. We all have rights that we hold qua being human, and that can't be taken away from us except through our own conduct. One of the most important rights is obviously the right to life. You can make yourself liable, you can forfeit your right to life in very limited ways. You can, for instance, like the scenario of the attacker in the dark alleyway, if you attack somebody, if you threaten culpably somebody else's life, as Professor Finnis pointed out, you may forfeit your right not to be attacked in return. But we have no reason to believe that all combatants have forfeited their right to life. After all, they might be on the side of the defender, of the state simply defending themselves. Or they may contribute to an unjustified threat without knowing so, or being coerced into doing so by conscription or circumstance. So the blanket permission to kill combatants that law gives means that it doesn't vouchsafe that who gets killed in war legally, that this killing is also morally justified. That we do no longer consider combatants' lives simply morally dispensable is expressed in the now notorious casualty aversion, specifically among Western societies. There's a widely shared intuition that combatants, simply because they are combatants, haven't lost their right to life. Nonetheless, again, just war theory, the ancient religious tradition of just war theory, sides with international law. Walser agreed that the society of a belligerent should be roughly, halved into, not necessarily halved, but distinguished between men in arms and everybody else. And that men in arms had a right to kill each other because they had allowed themselves to be made into dangerous men. They had lost their protection. Similarly, St. Augustine of Hippo was very sanguine about combatants' rights both to kill, but also their loss of a right not to be killed. These are only two examples where contemporary international law has very clear echoes of a long religious and moral tradition, yet it challenges contemporary expectations of morally appropriate state conduct. Why could that be? Well, I'll give you two reasons. The most obvious is pragmatism. I don't know whether that's a partial justification, but international law is not enforced like domestic law. So it needs to give belligerents an incentive to comply. Now, if war is about killing people and breaking things, then a law that doesn't simply want to be ignored has to acknowledge that. What could a law accomplish that would say there is an asymmetry between the attacker and the defender, and I'm only going to allow certain acts to the defender? Well, it would be ignored by the other side, missing the chance to do anything in war at all. States have very rarely embraced their status as unjustified attacker. But even if they did, they would presumably not comply with a law that stacks the decks against victory for them. What would a law accomplish that says to the soldier, you can only kill people on the other side that have forfeited their right to life? It is virtually impossible in the heat of battle to determine that. We're talking about something that involves a state of mind, that involves culpability, which is hard enough to ascertain in a courtroom, let alone on the battlefield. Impossibly to comply with the moral principle doesn't necessarily immediately invalidate the moral principle. But if we ask law to reflect such a principle, there is a cost. And it may be a moral cost, because one of the things we expect of law is that it is action guiding, that it relieves the individual of the burden of having to figure out how to act. And on fairness grounds, we tend to think for law, a legal ought implies can. So all international law has compromised character. And in the case of war, that compromise is quite painful. International law makes a pact with the devil of military necessity in order to secure compliance and be action guiding, and thereby get the opportunity to prevent the supposedly greater evil of completely unrestrained warfare. So maybe the morally best law, and I'm not saying this is the morally best law, but it is maybe not the one that directly repeats moral prescription. And this brings me to the second explanation for this divergence. Morality isn't all of a piece. I pitted the law against an individual rights-based, secular, cosmopolitan morality, where the locus of moral value is singularly the individual. St. Augustine of Hippo thought very differently. He valued above all else the sacred authority, the divine authority of the prince or the sovereign to command its subjects into a war, and therefore stipulated the duty of a soldier to follow the prince even into an unjust war. After all, they would be rewarded in the next life. We don't have to go all the way back to the 4th century to find a moral belief that values the community or the state intrinsically, beyond what the community may be valuable to the individual. And this is what Michael Walzer puts forward. So even in 1977, when the protocol that I mentioned was drafted, the idea that the individual, its moral or legal rights, are a matter of international relations was very new. The idea that individuals maybe retain human rights in war is arguably younger even than that treaty. So what does that mean for the appropriate relationship between morality and law? Well, the first thing that we need to note is that because international law does not vouchsafe the moral justification of all killing, at least not based on an individual rights-based morality, means that maybe we don't want to have normative conversations on war purely in terms of legality. Legality is not the be and end all of moral justification when it comes to war. But from the point of view of international law, we face a dilemma. International law that regulates killing and destruction needs to be based in morality. We would otherwise, as I said, consider it inadequate. It is the moral cloak of legitimacy that states seek when they try to convince the international public that they act in line with the law. Legality is a very weak end in itself. It is the hope that through legality we achieve morality, moral legitimacy, that states pursue when they try to convince the world that their conduct in war is legal. Yet treaty law is static while morality evolves, creating the danger that even only 30 years after a treaty enters into force, it is already out of touch with widely shared moral intuitions. In addition, the international system is pluralistic, it is heterogeneous. You don't need to be a moral relativist to understand that currently in the international system there are different traditions, different moral codes, and that the philosophers that I cited are to some extent children of their time and their culture. So what we expect, or one expectation we have of international law, and that is a morally valuable task, is to bridge the divide, to transcend different moral traditions. So on the one hand, Christianity inspired this law. It probably inspired the Tsar's idea to have a conference 150 years ago and lay down some rules, lay down some morally inspired rules. And we need this reflection of morality in order to consider the law a legitimate code for determining conduct. At the same time, if this legacy, this Christian Western legacy, is too obvious, it gives a reason to countries or to belligerents that do not necessarily adhere, do not recognize it as their own. And that is bad news even for countries who do consider the Judeo-Christian just war theory as their own moral tradition. Because the countries that they're likely to encounter on the battlefield may well be those that don't. Thank you.
Thank you very much. Now we have a possibility to make our discussion even more practical, because the next presenter, Mr. Michael Sweston, one of the founding fathers of St. Petersburg Legal Forum. He is a classical British lawyer, of course, graduate of Oxford University, as you could have guessed already, royal councillor, has a huge amount of experience of various practices, international arbitration, the expansion of British law and British lawyers all over the world, Mike, is it a consequence of good understanding of legal principles or well-planned soft aggression?
Thank you, Minister. Ladies and gentlemen. Well, about 30 years ago, when I began my time at Oxford, I attended an introductory lecture by Professors Finnis, Dworkin, and Joseph Raz on natural law. And I regret to say, especially sitting here, given my present task in this distinguished academic company, that after listening to the introductory lecture, I chose not to do their course. That has a benefit from your perspective, because it means that nothing that I say will be constrained by any kind of Oxford orthodoxy, if there is such a thing. And as a practicing lawyer, I would like to put forward a practical theory of natural law, which is distinct from many of the theories that you read, for example, in Professor Finnis's seminal book, because it does not rely upon religious faith, it does not rely on God or the uncaused cause, as Professor Finnis might call him. I would suggest that this non-faith-based route is desirable, because whereas nobody can doubt the value of religion in the past, providing the cement that binds society together and allowing people to function, as we see today in the Middle East, religion is increasingly used as a tool of very destructive differentiation. And so if we can come up with a route to morality and natural law without religious pitfalls, I would suggest that paradoxically that would be more ecumenical, inclusive, and useful to mankind. So, where does law come from? Does it come from religion? Does it come from social evolution? My answer is practical necessity. We've got a picture there of a saber-toothed tiger, the kind of practical necessity that growls out at you out of the darkness beyond the light from your campfire, that makes people come together for fear, makes them huddle together. The simple fact is that man is weaker than nature, and weaker than human nature, perhaps most of all. And that is why men have always found strength in numbers, but for numbers of people to live together, they do need laws. And therefore, if we ask why do we have laws, it's nonsensical, I would suggest. We have them because we exist. It's like asking why a leopard has spots. It's part of the nature of our existence, and it's a facet that was essential to our evolution. Now, every practical lawyer needs evidence, and I brought some with me. The oldest law that I could find, the Code of Hammurabi, getting on for 4,000 years old. And my comments on it will be brief because I can't really read it from here. But if we look at Rule 2, we see that trials in those days were much simpler. Essentially, people were thrown in the river, and if they swam and survived, then their cause was vindicated, and if not, then it didn't really matter for them. It does convey an important point, which is that some decision is better than none. And indecisive judges now should take note. We also see in Rule 4, nearly 4,000 years ago, the origin of civil compensation for wrongs. And if we go to the next section, we can see a very illustrative rule that tells us about the nature of society in which law evolved. If there's a robbery, the community bears the loss. And next, if persons are stolen. In other words, if the necessity is a raiding party that comes upon the community and steals people for slavery, again, there's compensation to the family. The community bears the loss. Now, under the code, there wasn't great strength for human rights. This is the small part of mercy that I found in it, that if someone becomes indebted and sells their family into slavery as a result, after the 4th year, they're set free. But that is the limit of humanity there, because the rest of it is about throwing people in rivers and chopping off various parts of the anatomy if wrongs are established. Now, what do we draw from this? What's the common theme? It is practical utility in the face of practical necessity, and the need for a community to operate together in order to survive, and for the strong to support the weak and those who've been injured, and so on. Now, of course, rules need authority, and the best kind of authority is that wells up from inside as an inspiration to serve one's God as opposed to oneself. And that's what Joseph Raz calls inspirational authority. It's very powerful, and some might say that it justifies Voltaire's famous aphorism that if God didn't exist, it may be necessary to invent him. But whether the authority of rules is inspirational or imposed, I would suggest that there are 3 aspects to law, 3 primary colors, if you like, from which the rest are mixed. The first is non-interference. Your freedom to swing your fist ends where my nose begins. But equally, you shouldn't poke your nose into other people's business. The essence is non-interference. The second primary color is keeping your promises. And I've set out there, too small to read, but passages from the Quran, the King James Bible, and the motto of the London Stock Exchange. It's fundamental to a functioning society and functioning business now to keep your promises. Without that, if one thinks about it, we could not have division of labor and specialization of labor. Lawyers would not be lawyers because they couldn't be confident of being paid. Clearly, society would fall apart at the seams. Now, a third principle is respect. Respect for difference, respect for individuals within society. And really, it's a subset of the first 2, regard for promises and not interfering with fellow members of society. But I would suggest, and there's not time to analyze in any depth, but those principles account for the whole mosaic of law on a domestic and international level. We see compacts between states, compacts between people within states. We see within the framework of international law respect for difference in the conflict of laws that allows different laws to be applied by national courts because they're more appropriate to apply. So how does this theory of evolution of law fit with public international law? Well, I would submit very well. And I would suggest that it meets Professor Finnis's point that public international law is not really law. I would suggest that it is, and it's law which is normative for the same reasons as led to the evolution of domestic law. Why do we have international law? Well, the best answer, I would suggest, was given by Douglas Hurd, a former British Foreign Secretary. And again, I can't read it from here, you can. But he made the point that no country in this world, this integrated world where each country does different things, some supply, some manufacture, some provide banking, no country is strong enough to provide the needs that its people require entirely by itself. international law has developed in order to allow states together to serve the purposes that is beyond the reach of any of them individually. So what's the essence of public international law? I haven't got time to go through all of the elements of it. I'm going to concentrate on one, and that is non-interference. It's a well-established principle of public international law. The duty of a state to refrain from any action or attempt in whatever form or under whatever pretext to destabilize or to undermine the stability of another state or any of its institutions. So there you have it. Good fences make good neighbors, and non-interference is critical. I brought along a couple of counterexamples, chosen entirely randomly, but I thought you might enjoy them. The first is the decision of the International Court of Justice in the Nicaragua case between Nicaragua and the United States, where the court helpfully printed the CIA manual on how to destabilize governments and cause revolutions. And you see that there's recommendation of political assassination, creation of martyrs, and deployment of the martyrs in civil unrest. It's actually a bad example because it's historic. It goes back to the 1980s, and obviously, after the court decision, there have been no subsequent editions of this manual, and therefore any resemblance to events subsequently anywhere around the world must be entirely coincidental. But it's important to recognize that the International Court of Justice said that this kind of thing was unlawful. And why? Because this kind of thing leads to destabilization, disruption, and conflict on the international plane. Now, interference in breach of that principle can be more insidious, and even when it is born from the best of motives. I should just pause to note that state practice also supports non-interference. But as to interference from the best of motives, I draw attention to the Aleksandr case, a case from the European Court of Human Rights. It dealt with the obligation of British forces to apply the European Convention on Human Rights in the south of Iraq. And Lord Roger there, again, that is much too small for me to read, hopefully the young amongst you can, he made the point that formally the court applied the convention within the territory of states. And if it went further than that, it ran the risk of human rights imperialism. In other words, we should not assume that our values are better than those that prevail in other parts of the world. And so we come to a conclusion. The rule of law. Throughout this conference, everyone has spoken of the rule of law, and all amongst us, I suspect, would unhesitatingly state their adherence to it. But what does it mean, really? I would suggest that it's principally a rule of process rather than substantive content. It is, if you like, the golden thread. It is fairness. What it doesn't do is prescribe what has to be the substance of the law that the rule of law protects. And as to that, I would suggest that there needs to be respect. Respect for diversity of law, religious faith, political approach. So with the primary colors of non-interference, keeping your international bargains, and respecting difference, I would suggest we have the best recipe for a secure, peaceful, and prosperous world.
Спасибо, Майк.
Thank you very much, Mike. It was indeed a beautiful speech. And summing up the discussion goes to Vladimir Isakov. This is an uneasy task, but he has experience both in theory and practice, in Parliament and in international affairs. Mr. Isakov, the floor is yours. Mr. Chairman, dear colleagues, when I saw the list of questions proposed for our today's session, I felt warm at heart because such very big questions really worry people when they are young, or students, for example. After that, we would come to think about pettier, smaller problems, but of more practical nature. But this moral and legal reflection is required to identify the categories and notions, basic ones, that form the basis of law. And we need to test our practice, our academic attempts against such core principles and theories. Well, I would not be able probably to discuss all the 7 questions. Maybe I would pick up 2. One of those is the challenge of natural law. A few years back, when I took part in a similar discussion moderated by Vadim Kartashkin, and I asked him a question. Today's physiology really knows how a human body is conceived and developing. We can say to which exactly point the fetus would get the hands, the brains, etc. But my question is, do you know at which exactly minute the natural rights emerge and exactly at which place of a fetus you would find those natural rights? Vadim said that I don't want to answer that question. And then I asked another question. Take the ancient times, take all those slaves in Greece or Russia. Did those people have natural rights? And if yes, then why wouldn't those natural rights be protected? Well, Vadim said that, of course, fetus would have some natural rights, but also protection mechanisms inside the body of his or her mother. But, well, I mean, the result of this thinking was that sometimes we create this myth of having something natural. I would probably understand why American constitutionalists or the French would really need such a myth of natural rights. But why would we need that in the 21st century? We confuse our students, we confuse ourselves about the social nature of rights. And rights are born not in an incubator, but in a political and social reality. Communities give birth to such rights, but they can also infringe on those rights and take those rights away. But this is not to say that we are getting those rights from above, from the one side or from another side. I think that probably many would disagree with me, and of course there could be comments and remarks and criticisms of my position. One of those could be that natural rights have several tiers. There is some top tier rights, like the right to life. If you cancel this right, then all other rights are senseless. So that's a group of top priority rights. They may be called natural rights, but people would be confused about the nature of those natural rights. So if you want to pick up the most important natural rights, then probably you can categorize them. I'll probably give you a second caveat and say that humanity took a long way in understanding rights. And a number of fundamental rights are reflected in international documents. This means that if a state refuses to recognize those rights, that state actually opposes humanity. And the whole world developed a certain position, a certain state view, and reflected this in an international document. So even if you believe that you don't recognize those rights, you need to also recognize that you would be opposing the whole world. So there is a group of rights that exist regardless of judgment or failures or foolish deeds of any state. Third point, in parallel to the understanding of the role and significance of such rights, we also saw the emergence of an international protection system. Mr. Zorkin actually mentioned that today, and he said that this is a system which also has some deficiencies, but there is a system in place, and the system is in place and developing and progressing. So man is not really defenseless in the face of states or authorities. The social nature of such rights is clearly seen in the history of the development of such a document as the Universal Human Rights Declaration. Actually, I saw a little brochure about this, and I was amazed how Eleanor Roosevelt, a small fragile woman, managed to organize an 18-month-long discussion where she managed to bring together and closer together very opposing viewpoints on human rights. It was a debate with many parties, it was also narrow debates and many views on the human rights. But the result was the adoption of this Declaration of Human Rights. Fortunately, my country, the Soviet Union back then, did not support that declaration. But I hope that the 70 years passed, we became smarter. So my summary is that natural rights does not mean that they exist in nature. They are generated by they're generated by society, and unless we want some false science in place, we need to really think about the social nature of those rights. Of course, we need to develop the protection mechanisms, but let us avoid creating myths in this area. The second point about the linkage between morality and law. My point is that both moral values and legal values, they have one and the same boiling pot, if you like, where you would have various experiences and views boiling and rethought and revised and reformed. And we are talking about the experiences of people, corporations, countries, etc. So the moral values are probably on top in that boiler, in that pot. These are light fractions, if you like, that would tend to come on top. And any values that are not good enough, they would be sinking to the bottom. Legal norms would come as the second layer in that soup. Very rigid institutions that have protection mechanisms attached. But this is the result of one and a single social process of constant rethinking of human experience. do moral values interact with legal norms? Let's just rephrase this question a little bit. Let us imagine, or can we imagine, that in the several thousand of human history, we never saw any change in the relationships between the legal norms and moral values. Of course, the relationships changed and will be changing.
Where do I see those changes? We have been reminded of the Hammurabi Code, one of the most important monuments. I could quote Russian Pravda, the Russian code of laws of the 12th century. In the ancient times, we see a lot of religious dogmas and the casual nature of instructions. However, in modern legislation, you will see definitions, you will see norms defining principles. Our moderator has made a very good point about that. You will see norms that define goals, micro and macro processes and procedures. What is the problem here? I think that the problem is that the life of today's man, or woman, or human being is very different. So our modern way of life is project-based, if you will. A person is included into various goal-setting systems on the scale that never existed before. If you think about that, you will see a number of goal-oriented systems of which you are part. But the behavior of a human being within the goal-based system and outside such a system is regulated in very different ways. Therefore, legal thinking, legal constructs are very complex today because they have to take it into account, this phenomenon, and they're going to become more complex. And this doesn't apply to morals. I'm not an expert in moral norms and regulations. I think that the language of morals are changing, but not to that extent. Therefore, we have a deviation between law and morals. Law is becoming more and more complex technically, and while moral remains more or less on the same level of technical complexity. This is the first issue. The second issue is that today we have such a phenomenon as avalanche or advancement of technical and legal regulations that currently regulated in those areas that are currently regulated legally. We have more and more technical norms, and the range of issues that are regulated by technical standards is growing. And these norms are considered to be morally neutral. Legal norms have to be morally assessed, but here, what do we do with technical specification? It is neutral from the moral point of view. And I would like to draw your attention to the following. We have seen the creation of a huge number of books and other works about describing the future the future society that will be guided only by technical regulations without any legal regulation. Technical regulation will be about all they will have to. But I don't think that apocalyptical forecasts should be made, and I don't think it will happen tomorrow, the day after tomorrow. But I think that the general trend is in this direction. The field of morals and law is becoming smaller, while the domain of technical regulation is expanding. And we need to think about that. And at some point, we might see that the laws and morals are in a very small ghetto, while everything else is occupied by technical regulation. What shall we do in that situation? Shall we make trenches and try to stop those regulations? Shall we think about technical regulations so that we don't do not reject their moral nature at all? Because Regulations of food products, is it a purely technical issue? No, it is related to human health. And this is not a purely technical regulation. How the government determines whether the foodstuff is appropriate to eat or not. It's not only a technical issue. So technical regulations should probably also be assessed comprehensively. How can this be achieved? The form that we have, the establishment of technical specifications as laws, it proved to be ineffective, and we did away with it. But how should this be done? This is still an open question, but we should think about that. Thank you very much. Thank you very much, Vladimir. Okay, we spent more time than planned, and this is a bad job done by me, by the moderator, but this confirms my quest for knowledge, one of the main goods mentioned by Professor Finist. We don't have time for questions, answers, or discussion. We can act in two ways. Number one, I can ask respected speakers who have still 5 or 10 minutes to spare to stay in this room and ask the people to sit here for another 5 minutes if there are questions, and we can discuss them. If necessarily, we will just all put our money together and extend the lease of this auditorium. But the second option is better, and the whole Rubinstein Street today is given to lawyers. 11 cafes and restaurants have been hired by law firms, so we can move all of us to one of those places. Both options are quite open, but now I would like to ask you if you have 1, 2, or 3 short questions from the floor to the speakers. Thank you. Evgeny Pisarevsky, Russian Social Security Fund. I have a question to Professor Isakov, and our foreign professors can also make a comment if they will. Thank you for very fundamental presentations. They've been most useful for us. Professor Federanovsky, who used to teach at St. Petersburg State University and then immigrated to Yugoslavia 100 years ago, said that the legal foundation for the Russian state has always been not a system of subjective rights, the combination of which would create the possibility of a state whole, but the system of objective laws that were aimed at ensuring the whole integrity of the whole state, and through this the insurance of its constituent parts integrity. So an individual received a lot of goods from because of the statehood and vast nature of our country. Well, Vladimir, we can express the same very short and simple. In Russia, what is ruled was not the law but the authority, the powers to be, and the citizens received more goods from it than if laws would be the guiding force. Unfortunately, this is so. Although in our constitution we have written that Russia is a law-based country, but even the head of the Constitutional Court today said that we are on the way to creating a state of a rule of law. I'm hoping that we are on this route, but we can't say that we have created a country that is already based on the rule of law. It is too premature. Therefore, the relations between the authorities and law remain a big problem from Russia, and this problem will remain for a long time. How this is going to be solved, it depends on the legal community that has come to this forum. Are there any further questions, please? I'm Doran Skiller, I'm from Germany. I have a question to you. Victor, if I understood you correctly, you said that we need objective principles of law. On the other hand, I think you were saying that one of such principles is faithfulness and conscience. I think that conscience is a subjective principle. Therefore, I want just to clarify the relationship between thoroughness and objective principles. It was probably conscience, yes. Well, the law as a whole is a subjective thing, and it was quite appropriate that our colleague compared technical regulations with law. You cannot, this is not precise science. They can be guided by the principles which we hypothetically think do exist. Further development of law and its understanding by law enforcers, judges, the level of subjectivity is increasing with each next level, and it may turn out that the deal that was concluded in a legal way, in fact, has very little legal in it. But it is interplay of both subjective and objective factors. Well, I'm sorry if I couldn't express myself properly. If the principles that require a high level of subjectivity and understanding and application still are complied to a greater or smaller extent to those objective laws that define the image of man and society in which he or she lives. So this interplay of subjective and objective factors, well, it always will be here. There was another question.
My name is Klaus Reichert. I'm from London. Might I congratulate you, sir, on a stupendous panel. The subject of moral foundations and natural law is one very close to my heart. I'll make a disclosure to everyone that I'm a practicing Catholic, and morality touches upon my life every day. And I'd like to share a quotation from Emeritus Pope Benedict XVI, which I'd like your reaction, or anybody on the panel's reaction, to how this might interplay with law today. And if you don't mind, with your permission, sir, I'll read from my iPhone, so I'll get the quotation correct. This was in the context of democracy, and it was written about 10 years ago. And His Holiness wrote, "If the moral principles underpinning the democratic process are themselves determined by nothing more solid than social consensus," and by that I think he meant contemporary social consensus, "then the fragility of the process becomes all too evident." So therefore, the fragility of that process, if it's determined by something as fleeting as present social consensus, is that a lesson that perhaps can be extrapolated for natural law and the practice of law today? Thank you.
Thank you very much for this question. I didn't understand who you addressed it to. I will say a couple of words, okay? I think that all the speakers were talking about the same thing in different ways, of course. In order for law to be applied, there must be certain conditions which may be more comfortable or less comfortable. It depends on the state of the world, war and peace, the state of human minds and morality. I think that today the society is being fragmented. It is capsizing, and it breaks down into various segments based on projects, about which projects Bahimar was saying. And here the consensus is very different. Consensus is not based on universally shared values, but depends on pragmatic interests which are generated by a group in a more or less chaotic way, or may be imposed to this group by using specific technologies of manipulating the human mind that are very numerous, and they're going to proliferate further in all probabilities. Mr. Minister expressed my idea in slightly different words. I think that any process, any idea, any solution that is based on reason and rationality is fragile. Because reason is not perfect. It selects certain things from the overall picture and looks for a solution within these limitations. Life is much more multifaceted, and the solution doesn't go anywhere. I think that the problem is not to reject reason. Then what? What we are left with? Force? Violence? Not the best solution of this problem. But on the field of reason and the domain of reason, we must look for a plurality of solutions. Let's take today's legal practice. Many solutions are proposed purely in national interest. Well, it is a possible and plausible system of coordinates. National interests must be respected, but if we seek a solution only within the system of coordinates, it becomes rough, and it infringes upon the interests of men and women. Excuse me.
Answer both, make some response both to the question about conscience and the question about consensus, and indeed perhaps the observations about reason. Very briefly, consensus is absolutely necessary to the existence of any system, whether it's a democratic system or an authoritarian system. If it's a system of law, an order at all, it is fundamentally one of consensus. However, there are good consensuses and bad consensuses. There are immoral and moral states of social consensus, as we all know. Similarly, conscience is absolutely indispensable. Every principle that we call an objective principle of justice is one that our conscience has discerned. Everything I said in my talk was about the formation of conscience. I did not use the word conscience. I used terms like reason or think, and think correctly, think reasonably, and so on. These were all observations about conscience. But conscience can be mistaken as well as correct. It could not be mistaken unless there were correct conscience, and it could not be correct conscience unless there were the possibility of mistaken conscience. So we only talk about subjective conscience when we judge that somebody's judgment is mistaken. So to illustrate the problem of the last speaker was addressing, I think, consider this: much of our law, not the part that says no murder, no arson, no torture, no rape, but much of our law, most of our private law, most of our civil law, is in more, to one extent or another, more or less like our traffic law. Now, so we choose a side of the road to drive on, we choose a speed limit, we choose various conventions of behavior on the road. All of these, each one of those is fundamentally a social option made either by consensus directly or by legislation to which there is general consensus because it's been enacted lawfully, etc. A society, in making those judgments, is not compelled by reason to any of those judgments. Suppose we say our speed limit is 40 kilometers per hour in such and such an area. The consequence of a speed limit of 40 kilometers per hour is thousands of deaths and injuries every year. But we as a society consent to the risk that we impose on others and others impose on us, more or less. We could debate the matter and decide we no longer want to accept those deaths and injuries. Let's make the speed limit 5 kilometers per hour. Walking speed, for all motorized vehicles, walking speed. Now, that would have many great advantages for the life and other basic values of human persons. It would, however, subject our society to many great sacrifices in values, including the value of life. We could not move people to hospital in a hurry. The level of trade and intercourse and etc. would be impossible. None of us could be here, or very few of us could be here, only the locals, and so forth. So, as a society, we confront choices like this, and we make a decision by consensus within a framework of reason that says, well, reason requires that nobody drive in order to kill others, and reason requires a few other fundamental moral norms or legal norms, but beyond that, we must seek consensus and do so by discussion and compromise, and that's an act of conscience and conscientious judgment of us all.
Большое спасибо, профессор.
Thank you, Professor. I think that here we need to stop our deliberations and just remember what our esteemed professor mentioned yesterday during the plenary session, is that the role of each of us is of paramount importance to find a solution to all these questions, and the way we, all of us, would define the moral imperatives, whether it would be in line with the positive law in the place where this person is, or maybe there would be a mismatch between the moral imperative and the legal system, and this would identify the state of things in our planet. So let's not overplay the role of our judgments and our reasonable or unreasonable deeds, but think broadly. I would like to thank my colleagues, the panelists, who indeed had very interesting ideas and speeches, and I also would like to thank the audience for their attention. So if there are any remaining questions, so please address them directly face-to-face to the panelists of your choice.